Okay, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning, everyone, and welcome to the Massachusetts Appeals Court oral argument for today, July 9th, 2020. My name is Amy Blake, and today the panel for your first three cases will include Justice Peter Sachs and Justice Joseph Ditkoff. For our last three cases, Justice Sukyoung Shin will be joining us and Justice Sachs will be leaving us. This is a virtual sitting of the Appeals Court that we are live streaming. We are in certainly extraordinary and unprecedented times, and I hope everyone is doing well and safe and healthy. In order to make today happen, we owe a deep debt of gratitude to the Clerk of Court, the staff of the Clerk's Office, our administrative staff, our colleagues, our law clerks, and the like, without whom this would not be possible. Today, we're going to hear 6 cases. After the first 3, we will take a short break. If you are watching remotely, you do not need to do anything. Just stay on the line and we will return. And even though we are on a live stream, we do proceed like we would in the courtroom. So each side has 15 minutes to argue and there is no rebuttal. If you are in fact splitting your time, which is the case for the first case today, you will let us know who's going to proceed first and how much time you each will need. Only one lawyer may speak at a time, and for purposes of Zoom, the other attorneys' microphones will be muted by our clerk's office staff. You will see in the left-hand corner where the seal currently is a countdown clock once we start our actual case hearing. Unfortunately, we don't have the 3 lights, but you will have the 15-minute or 7.5-minute, depending on what you're arguing, countdown. The proceeding is live and being recorded, so remember that anything you say during these proceedings will become a permanent part of the court record. If there is a technical problem with Zoom or any particular participant, we will work to get that fixed quickly. Hopefully we won't have to suspend the argument, but if we do, we will preserve the time on the clock and we will restart as soon as our technology works again. And before we hear our first case, I would like to ask everyone to think for a moment and take a moment of silence in honor and in memory of one of our beloved judges who passed away recently, Justice George Jacobs, who was a member of our court, an integral member of our court, who will be greatly missed. So if we could all just take just a quick moment to think about him and reflect on his life. Thank you all. With that, we are going to call our first case this morning, which is Commonwealth versus Jose Santos and Anderson Garcia, docket number 19P799. Mr. Tewari, I understand you'll be arguing first for 7.5 minutes. So when you are ready, counsel.
Thank you, Your Honor. May it please the court, good morning. My name is Attorney Chetan Tewari. I represent the appellant, Mr. Santos. The primary issue in the instant case on appeal is, did the Commonwealth provide sufficient evidence of my client's constructive possession of a firearm?
Now, your client was the passenger, correct?
My client was in the driver's seat, Your Honor.
Oh, I'm sorry, you're in the driver's seat, I apologize.
To prove constructive possession, there are three elements: knowledge, intent, and ability to control. The 2 elements which the Commonwealth failed to proffer sufficient evidence for were, in this case, knowledge and intent. And sufficient evidence in this matter is governed by the Lattimore, the standards set out in Lattimore. So first, the Commonwealth contends that the alleged furtive movements that my client made during at some point between the time where Officer Dubé noticed them sitting in their car and pulling them over is sufficient to infer that they knew about the gun. In fact, they're saying that the movement was them trying to hide it. But it's been established in case law in this court, the Supreme Judicial Court, and Federal Court of Appeals that movements alone are not enough. if the only evidence there is movement, the jury is required to effectively speculate that the movement is because the defendant knows about the contraband.
What if the movement is in the direction where the contraband is found? And here, both of the defendants were leaning down and towards the floor in the passenger area.
Your Honor, so that still is not sufficient. And I think Brown actually is quite on point, where in that case, the passenger and the driver were both bending forward in unison. And in that case, the firearm, I believe, was found underneath the passenger seat. They're both bending forward in unison, but that was not sufficient because it still doesn't lead to the conclusion beyond a reasonable doubt or sufficiently enough to say that they were trying to hide the gun. It effectively says they're present in the vehicle, they moved, and because they moved, they knew about the gun, were trying to hide it, which is speculative. And in this case specifically, Officer Dubé offered in his testimony offered two equally probable, if not more probable, explanations for the movement. The first was he may have been reaching for his registration. The driver may have been reaching for the registration. Or two, there was cash strewn about in the glove box. They were possibly cleaning that up and putting that in the back.
I want to ask about this idea that there are equally possible inferences, and that where there are, neither can be regarded as proven beyond a reasonable doubt. Does that apply only where the inferences are conflicting? Or if the jury could say they were both picking up the cash to hide it or to put it in the glove compartment and hiding the gun, and there's nothing inconsistent about doing both of those, then is there any reason the jury can't draw both the inference that favors the defendants and the inference that favors the Commonwealth, and therefore would there be sufficient evidence to convince?
So in Wallace, excuse me, Wallace does speak directly about conflicting inferences, I believe, and if they're equally probable and they can both happen, that is actually a question I'm going to have to look into a little bit more, Your Honor. I'm not certain about that. I do know Wallace does speak about conflicting inferences.
Do you disagree with the proposition that the main difference between Diaz and Brown is that in Diaz the firearm's in plain sight, and Brown it's not?
Yes, I believe that is a large difference, and this case is more comparable to Brown because the contraband, the weapon, was not in plain sight, and that's something that I do want to touch upon in some detail. The Commonwealth.
Before we get into that, if we find out, I mean, if we determine that a jury could find it was in plain view, I'm not saying we're going to find that, but if we did, do you have anything else to distinguish Diaz, or is that it? Does it really come down to the plain sight issue?
For the knowledge element, the plain view, I believe, is one of the key factors. However, the intent is something that is distinguishable, something that I'll discuss later, and I believe my co-appellant will also discuss. Even if the weapon was, even if this panel finds the weapon to be in plain sight, there's still the question of intent, and that's sort of the next step of the analysis. But the main issue here with respect to knowledge, I believe, is the plain sight. And I understand from the Commonwealth's brief, and we've filed, both myself and the co-appellant have filed a motion to strike, because the Commonwealth's brief has made some misstatements. For example,
I'm not really looking to strike essentially what a panel of this court determined, that the gun was in plain sight, and isn't that what the prosecutor is referencing in her brief?
No, so the prosecutor references that decision, which that was not in the record. That was not in the record before the jury. That was not in the record at trial before the trial judge who decided on the direct.
So we can't consider it?
No, not for a sufficiency claim. But more than that, the quotes that the Commonwealth has used, they've been misshapen to try to indicate that this gun has been in plain view. We've cited that in our in our motion to strike, but more importantly, the words plain view in approximately 300 pages of transcript, the words plain view don't show up once. The prosecutor, the trial prosecutor, didn't even argue in their closing that this gun was in plain view. And that's because there is no
But do
evidence.
you disagree that Doobie testified that he could clearly see the brown handle of a firearm underneath the passenger seat after he illuminated the interior of the car with his flashlight?
I do disagree with that because he also had to lean in and look for it. There was some effort he had to make it, and the gun was obscured by the
Did he have
passenger.
to move something? Did he have to open something, or did he had to bend over?
He had to bend over and look underneath the seat. And Snow clearly states that for an object to be in plain view, it has to be clear to the naked eye without obstruction. So for Officer Dubé to bend over in that fashion, he can't say it's in plain view. And it's definitely not in my client's plain view, who's in the driver's seat. So,
Mr. Tewari, can I just get a very brief reaction since your time is just about up? If the jury could find that the movements of the defendants were an effort to hide the gun, then it wouldn't matter whether where the gun ended up was in plain view or not, because their effort to hide it would demonstrate knowledge and ability and intention to exercise dominion and control.
I would respectfully disagree, Your Honor, because Brown and Almeida both say that there needs to be something more than movement. So even so, for the jury,
if the jury could find that their movements were enough to that their movements were aimed at hiding the gun, then where the gun ended up, whether its hiding place was a good one or was in plain view, doesn't really matter, because the act of hiding, if the jury could find that that happened, and I'm not saying we will, but if, then wouldn't that make it irrelevant whether the officer had to, could see it just by looking in the window, or whether he had to lean down and look way back under the seat?
I think, Your Honor, that the issue is not so much with whether they could find that he hit it properly. It's them, the jury, inferring that movement was to hide it. That's where the issue is, because there's not enough evidence for them to even find that without speculation or conjecture. Okay. And that's where the problem starts for the Commonwealth.
Thank you. I think we'll have to leave it at that unless Justice Ditkoff or Justice Sachs have any more questions for Mr. Tewari. No. Okay, thank you. Mr. Oswald.
Good morning. May it please the court, my name is Thomas Oswald and I represent Mr. Anderson Garcia. Just want to echo the arguments of my brother in regard to the evidence being insufficient as to constructive possession. Particularly, I want to touch on the intent prong of the elements that are involved here. Knowledge and intent require separate proof. And just to point out, the cases that the Commonwealth relies on in regard to intent all involve unambiguous bodily movement observed by police officers up close from the vantage point of a face-to-face or car window encounter. Our case here is completely different. We have Officer Doobie's view of Mr. Garcia's upper body from behind in his cruiser when he appears to bend forward at the same time as Mr. Santos leans over towards him, ducking out of view temporarily. The Commonwealth cases rely on evidence that officers observe specific individuals within a vehicle doing specific things with specific parts of their body, that be it their arms, their hands, their legs, their feet. Here, the Commonwealth admitted at closing argument, quote, "We don't know exactly how it happened." They said a couple things after that, and then they concluded by saying, this case is about two defendants trying to hide a loaded gun. This is the entirety of the incident. Mr. Santos and Garcia were in a car that was not stolen, not registered.
We've got the facts, so we don't need to hear the facts, but I would like to see what you think of the issue of whether the inferences about what they could have been doing with these movements are inconsistent. So if the jury could find that the movements were could have been both to hide the gun and to put the money back in the glove compartment, then is there any reason the jury couldn't draw both of those inferences and come up with a valid guilty verdict?
Any reason they couldn't? I don't think so. I don't think that that's possible, Your Honor. I don't think that, well, I think they could look at both and draw inferences, but I don't think the inferences are justified by any sort of evidence here. They're triggered by speculation, and that's because we don't have
really
enough.
What I wanted to ask is a simpler question, I guess.
Okay.
if you have two inferences, and if they're conflicting inferences and they're equally plausible, then the case law is fairly well settled that neither can be regarded as proven beyond a reasonable doubt. And so there may not be enough evidence to uphold a verdict. However, if the inferences are not conflicting, does that principle still apply?
I think I would state that it does, Your Honor. I don't have a particular case to rely upon for that, but I would say that it does apply.
Why?
I think here in this particular case, in the context of these facts, the other inference is that they were hiding the gun was not supported by the evidence that was provided in terms of the demonstration that co-counsel did with Officer Doobie in terms of showing where the firearm supposedly was in the vehicle.
That's interesting because the jury could see exactly where the gun was relative to the demonstration chair in the courtroom. And the jury could see at what angle the officer had to lean over to look at it, because he came down from the witness stand, as I read the transcript, and demonstrated how he leaned. We don't have that in the record before us. So what are we as an appellate court supposed to do with evidence that the jury saw in demonstration form that we don't have?
I think we look at the rest of, oh, sorry, Your Honor. I think we look at the rest of the evidence in context and look at Officer Doobie's testimony on direct examination, where he said it was underneath the seat. We look at the evidence on cross-examination where he confirmed that it was underneath the seat and that he had to illuminate the interior of the vehicle while leaning in from an undetermined angle.
So if he, sorry, go ahead, Justice Ditkoff.
So in cross, Officer Dewey says any normal person, if they were going to look into a motor vehicle, would have been able to see that firearm. What do you make of that?
There, and you know, I'm looking to that particular point, and I think if you look at the line before that, there's a line before that that essentially says any normal person leaning in from my angle, any normal person who is leaning in. And I'll have a page number site for you here.
It's 130, volume 130. And there is something about leaning.
Yeah, he said if you want to come in with a flashlight at 106, he said if you want to come in with a flashlight, and here's what I'd emphasize, this is the angle you'd be able to see with.
Right.
So that's implying that there was an angle that nobody was able to see with. That language on page 106.
Would you agree that if the jury, and assuming arguendo, that the jury could find that the movements of the defendants were part of an effort to hide the gun, then it doesn't really matter where the gun ended up when the officer found it and what bizarre angle he may have had to lean in at in order to see it, because their act of hiding it would constitute all three elements of constructive possession.
I think the problem is, Your Honor, that you don't have sufficient evidence here to infer concealment. All the cases that talk about concealment.
But just let me stop you there. You're going back to whether the inference that they were hiding it is justified or not. I'm asking you, assuming that it is that enough, regardless of where the gun ended up and whether it was in plain view when the officer saw it?
No, Your Honor, I don't think it's enough. And the reason why is in all the cases that talk about intent or knowledge as to collateral conduct by the individuals involved, there's at least some sort of prologue, some sort of beginning story that involves some level of criminality or some level of suspicion either before or in the course of the stop or afterwards. Here, they were stopped, immediately removed from the car. They were cooperative. There was no agitation, no signs of increasing nervousness as the police.
But if they both had been handling the gun when the officer looked in the car, then there would be no question about constructive possession, correct? Regardless of how cool and calm and collected they acted, and regardless of the fact that they hadn't driven away at a high rate of speed or appeared to evade the officer. So really the question is whether their movements could be construed as an attempt to hide the gun.
I'd say if you had something more than movements of the upper body and the shoulders, and again, the Commonwealth did not produce evidence that showed exactly what Officer Doobie, the entirety of their body, what he could see in there. We don't even know what kind of car was involved here. The Commonwealth didn't even produce evidence as to what type of vehicle, any of that information. So I don't think we don't even know that any movement was made by anyone's arm. But if there was evidence that it was in their hands, certainly it wouldn't be, there wouldn't be much doubt here unless you look to the Romero case. And I think in the Romero case, you could see where the firearm was in plain view. It was in the occupant's hands in the passenger seat next to the driver. So the driver knew it was there, but there's nothing that showed that he had any intent to exercise dominion or control over the firearm.
Unless the panel has any other questions. Thank you, Mr. Oswald. Ms. Johnson.
Good morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. I'd first like to address Justice Sachs' question regarding the conflicting interest or the multiple inferences at issue in this case. And first, I would argue to the court that these are not conflicting inferences here. Here, the jury could have found both that the defendants were attempting to conceal the firearm and that they were attempting to hide the money in the glove compartment. But I don't think the fact that they could have found both negates the fact that it was proper for them to come to the conclusion that the defendants were attempting to hide the firearm. And next, I would just like to
stop you there and ask about the footnote in Wallace, which addresses this issue. And I'm just, sorry, fumbling for the quote. But Wallace, the footnote in Wallace does not specifically talk about conflicting inferences. It says if you can, it approved an instruction that said if there are conflicting inferences, or if there are reasonable inferences and one favors the Commonwealth and one favors the defendant, then you have to draw the one that favors the defendant. So I'm wondering whether you think it's implicit in that footnote that the inferences were conflicting, or whether there's some other principle about whether you have two equally plausible inferences that the jury has to draw the one that favors the defendant, and therefore that there's not sufficient evidence to convict.
I'll be honest with Your Honor, I don't have a great recollection of the case. I read it a while back, but I think, especially in this case, it would seem that the inferences would need to be conflicting, because as I mentioned, I think here, even if the jury found that the defendants were also trying to hide the money in the glove box, I don't think that negates from the reasonableness of the inference based on the evidence that was presented, that they were leaning over and attempting to hide the firearm after they realized that they were being pulled over. So I'm not 100% sure as to whether, as to that footnote in Wallace, but I think here the evidence is clear that even if the jury found that the defendants were doing both, that especially where the firearm was the illegal item that they were attempting to hide, that it was certainly reasonable for the jury to come to that conclusion.
Counsel, this wasn't instructed as a joint venture case. You've got someone hiding money, someone hiding a gun. So why are they both guilty?
I think with the evidence presented, it certainly is reasonable that the defendants were both leaning down. I think I have the testimony here that the driver was leaning over to the passenger side, and that he leaned over so far that his head came out of view a couple times, and that the passenger was leaning forward as well and into it like a downward position is the way that the officer described it. And I think where the gun was found, exactly where the defendants were leaning over, that certainly that is sufficient evidence for the jury to come to the conclusion that the defendants were attempting to hide the firearm. And I would also
respond to the issues raised both in the argument and the motion to strike filed by your brothers in terms of what a panel of our court said with respect to the plain view question.
Of course, and just for the court, the Commonwealth does oppose this motion to strike, and especially where this motion was filed pursuant to, I believe it was Mass Rules of Appellate Procedure. I believe it was 16E, which references citing to the record. And every quotation that I included in my brief and my argument includes citations to the record. And any portion, especially this plain view argument, was indeed that argument. And I don't think that rises to the level where it would be struck from the Commonwealth's argument or brief. And in regards to the citation to the appeals court decision in this case for the motion to suppress, That was just to show that based on the similar facts, and of course that decision is not binding on this court, and the facts were presented at the motion to suppress, and here it's the facts at trial. But that was just to show that based on the similar evidence and the recitation of the facts here, that a panel of this court did find that the gun was in plain view. So again, not binding on this court. It was just for the court's information that a panel of this court did find that the firearm was in plain view based on the facts presented there.
Why isn't it at least equally plausible that the defendants were picking up money from the floor? It seems to me that if you were hiding a gun, that could be accomplished with one individual leaning down and tucking the gun back under the seat, whether it was the driver or the passenger. Whereas picking up money, if money's scattered all over the front passenger area, you may need multiple acts of leaning down by both defendants in order to pick up all of that money and stuff it in the glove compartment. So why isn't it at least equally plausible that they were picking up the money?
I think the jury also could have come to that conclusion, but as I mentioned, I think even if the jury were to find both of those things, that the defendants were both involved with hiding the firearm or hiding the money, I don't think that takes away from the sufficiency that especially based on the officer's testimony, that they were both leaning over and into the area where the firearm was found. So I think even if the jury was to find that the defendants could have also been putting the money into the glove box, I don't think that takes away from the sufficiency of the fact that they were trying to hide this illegal item under their seat.
What's your reaction to the Brown case where the defendants bending forward in unison was considered not to be sufficient evidence of constructive possession or of an attempt to hide the gun?
Well, I think the difference here is that the gun was found in plain view. And I would just like to also clarify Officer Doobie's testimony.
Plain view, once he leans into the car and looks under the seat with a flashlight from an angle. And we have no evidence that the defendants sitting in their seats without the benefit of a flashlight could see that gun where it was when the officer saw it, do we?
Well, and I would just also like to clarify Officer Doobie's testimony later in cross-examination. He does clarify that he only leaned in a little bit. And I would also just like to point out that he did not have to move anything to see the firearm. He says he could clearly see the handle just by leaning in a little bit and turning on his flashlight. And I think the movements of the defendants also leads to the reasonable inference that they would have seen the firearm in the position that it was. I think where especially the driver was leaning down, his head went out of view multiple times as he was leaning over to the passenger side, and the passenger was leaning forward. I think based on Officer Doobie's testimony as to how easily he was able to see the firearm, it certainly lends to the inference that the defendants would have seen the firearm based on the way that they were moving.
Is your strongest case, I'm not sure if it's pronounced this way, Elise or Elise, is that factually the most similar to this case?
Yes, Your Honor. That would be the case that I believe is most on point here. And there's multiple defendants that they list in that case, but I believe it's the Elise defendant where the court talks about that the firearm was found essentially under the seat of this defendant. And the court says that even assuming that this firearm was not in plain view, which here, based on Officer Doobie's testimony and the movements of the defendants, it would have been in plain view. That even assuming that it wasn't, that the movements of the vehicle was enough for the jury to infer that the defendant had hidden the firearm after they realized that they were being pulled over.
So in that case, I think it was described as rocking the SUV. So are you suggesting that the defendant's movements are the equivalent of rocking?
I think the movements are equivalent in the sense that they lend to the same inference, that the firearm was being hidden. And in Elise, that was the rocking of the car, which the officer said was somehow coming from the back of the vehicle. And then in this case, the information leaning to that inference is the fact that the defendants were leaning over into the area where the firearm was found. So yes, I believe this case, the Elise case, is most on point for this case, and that here we do have evidence that the firearm was in plain view, which it might even make this case a stronger one than Elise.
The jury saw a demonstration by the officer of what he had to do to see the gun where he ultimately found it. We don't have that, the visual from that demonstration in the record before us. So we don't know what conclusion it would have been rational for the jury to draw from that demonstration. How do we handle that as an appellate court?
I think going back through the testimony and reading kind of how the gun was positioned, I mean, of course, we're not able to see it firsthand, but I think the way Officer Doobie describes it, he kind of describes it as the handle is pointing towards the front door, the kind of the barrel of the firearm is pointing kind of behind the driver's seat, and he distinguishes how far out the firearm is, and I think he says, oh, sorry, go ahead.
Well, but we don't know how far back the gun was underneath the seat, and we don't know exactly what angle he had to lean in at in order to see it. The jury saw both of those things. So what are we supposed to assume about what the jury saw?
I think it's the court can assume that that what the jury saw was in line with the rest of the testimony, that was presented by Officer Doobie as to how he just had to lean in a little bit to see the vehicle, to see the firearm, that he had his flashlight on.
That's a relative term, isn't it? How do we know what a little bit is in Officer Doobie's view versus somebody else's?
Of course, and that is one problem with the testimony, of course. But I think looking at the big picture, even though we're not able to see physically where the firearm would have been in the demonstration, I think the testimony is enough to establish that with the jury seeing this demonstration as well, that all of this evidence combined, it was reasonable for them to infer that the defendants had the requisite knowledge and intent to exercise control over this firearm. And if there are no further questions, the Commonwealth will rest on its brief.
Seeing none, thank you very much. Counsel, very nice.
All right, we are live.
All right, this is our second case, Commonwealth versus GAUDETTE, docket number 19P1623. Attorney Rose.
Good morning, and may it please the court. Rachel T. Rose for Craig GAUDETTE. The Commonwealth's case that Craig stole the car in the parking space of his mother Michelle's motel room in Westwood was made up of 3 parts. That they lived in the area of Fall River that it was stolen from a few days earlier, that medicine prescribed for him was found inside it, and that when he was arrested, he admitted he knew it was stolen. A successful suppression motion would have removed the third leg of that stool and weakened the case against him beyond the ability to survive a motion for a required finding. Counsel's failure to recognize that he had a valid basis for filing one was ineffective assistance entitling GAUDETTE to a new trial. Firstly, the motion to suppress would have raised a meritorious claim of illegal entry. They had the prescription bottle from the car, but critically, police did not discover the open probation violation warrant until they had already gotten Craig out of the bathroom he was hiding from them in. The analysis of reasonable belief that the subject of an arrest warrant resides within a home the police seek to enter. Yes?
Counsel, you agree once they know about the warrant, they can come in?
Yes.
So all mom says is when I went back inside, the police followed me into the room. Why do we think that is before they have the warrant?
In the police report, in the trial testimony from everyone, she is asked for her license before they hear the noises from the bathroom and ask who's in there.
But how do we know they're in the hotel room at that point?
We have the affidavit from her saying she went back inside the room. Nowhere in the trial, nowhere in the police report, nowhere are the police ever asked if they come inside that room when they hear somebody in the bathroom, ask who it is, get her license, and then are asking them about the stolen car. At the latest, they could also, if the police entered the motel room before they knew that the person in the bathroom's name was Craig, they would do so without any conceivable basis for finding a probable cause that he stole the car.
Even if they entered the room, what were the fruits of the entry that you say should be suppressed?
The fruits of the entry were the conversation where police testified that he said, my mother didn't know the car was stolen, which is...
But didn't that happen long afterwards, after they went back out to the cruiser checked the who was who on the database and then came back upstairs?
It's still fruits of the entry and the arrest, because if they entered the motel room before they even knew he was in there, then they would never have gotten to interrogate him otherwise. And now there's also a meritorious claim that the statements were suppressible as the product of an unmirandized interrogation, because the conversation was voluntary and spontaneous wasn't clearly established in the trial record, because police gave 3 different versions of what led up to it. In the police report, direct examination.
I can't think as fast as you talk, so can you just slow down a tad for us?
I'll try.
So before you get to the custodial interrogation, you say that the statement isn't voluntary. The statement that my mother didn't know anything about this?
Right. My mother didn't know anything. My mother didn't know the car was stolen.
Was he asked a question, or did he volunteer that statement?
Well, that's the question. The Commonwealth claims that this is something that he spontaneously volunteered as he's being handcuffed. But of course, it sounds like the reply to a question. In Commonwealth v. Woods in 1998, the SJC
what
reverses.
What does the transcript say, though? Rather than guessing, what does the transcript say? What happened right before he made that statement?
The transcript gives different versions. In the police report, it says he denied any knowledge of the car before he confesses. On direct examination, they testify they didn't ask him anything, that he just look up his name, arrest him on the open warrant, and he says out of the blue that his mother didn't know anything about the car. The prosecutor has to prompt him with the word stolen. And then on cross, he agreed they'd already told his mother the car was stolen. So what exactly police asked Craig or his mother to get those denials, and how close in time that comes to the confession, is not clearly established.
Well, counsel, your client's affidavit says, the police told me I needed to tell them who I was or they would arrest my mother too. Then they looked up my driver's license photo and then they arrested me. And everyone says that this statement about the mom happens during the arrest. So by your client's own affidavit, there's a huge gap of time where they're going and looking up the photo before he makes that statement. So even with the best facts that you presented, how do we find that statement wasn't spontaneous?
Well, they've just threatened to arrest her too. If he doesn't tell them, they're coming back up and they're arresting him. And so that could still be a response, because they think they're about to start putting the cuffs on his mother as well, to fulfill the threat that they made a moment earlier. I mean, at most, that's still like, well, at most it's a moment. And again, we don't have a very clear version of exactly how the sequence of events went and how much time was between them, because there's not a clear version given in the police report, and there's not a clear version in the trial testimony, because no one's ever really asked about these issues.
Isn't it your burden on a motion for new trial to show that you at least have a version of events that would make you win, not just say, well, we can't tell?
The version of events that would make me win is if the police, in fact, followed Michelle back inside the room when she was going to get her license.
And where do you have that in the record? Because that's not what mom's affidavit says. She just says when I went back inside and gives no indication of when she went back inside.
Right.
It would have been easy for you to do an affidavit saying, I immediately went back and before even my son came out of the bathroom, they come into the motel room, but I noticed that that's not something you could put in the affidavit.
Oh, well, the sequence of events has gone through very carefully in her trial testimony as well. So if you put together the affidavit and the trial testimony, it's clear that she comes out onto the balcony, she looks around for a second, they ask her to get her license, she walks back into the room to get her license. And if she's saying that she after I answered the door to police and came out on the balcony, when I went back inside, the police followed me into the room, and both her and police testify that she goes back into the room right when they ask her to get her license. So that places it very, very firmly in a moment in time that would be an illegal entry.
Where did she testify that she went back in the hotel room before she gave them her license?
I don't have the trial transcript in front of me, but it was in her testimony, and it was an the Sergeant Aylward's testimony that they ask her for her license and she goes back inside the room to get it. That they ask her for her license while she's out on the balcony and she goes back inside the room to get it.
Well, I'm sure she went back, but she can go back in the hotel room all she wants.
Right.
They don't.
Yes, and then she says, then in the affidavit, she says, when I went back inside the room, the police followed me back inside. And so the placement of exactly when she goes back inside the room can come from police testimony, can come from her testimony, but nobody says that she went back inside the room only after they discover who Craig was and pulled him out of the bathroom. So I did want to discuss the product of unmirandized interrogation. Commonwealth v. Woods, and I'm not certain I cited this in my brief, so I'm going to give the citation. It's 427 Mass 169. From 1998. That was a conviction for open and gross lewdness. And just like Gaudette's, my mother didn't know this car was stolen. There, the statement was, I thought you were interested in me, that's why I did it. It's very inculpatory, it's framed as a response. And in that case, the defendant was shouting it out to no one in particular. And but the SJC reversed it anyway, because they said there was no testimony on whether and when police had subjected him to direct questioning beforehand. Now here, we know that they did subject them to some direct questioning beforehand. So my argument is that we don't have enough to conclude that his confession was admissible, because that interrogation, which was definitely custodial and definitely absent any Miranda warnings, had stopped by the time he made this statement.
But what was the interrogation?
In the police report, it said he denied any knowledge about the car. So they're asking him about the car. These are eliciting this is the standard interrogation, is trying to elicit an incriminating response. Say, yeah, that's my car. They're trying to get it from Michelle, and then they're trying to get it from Craig.
Someone could deny something without being asked. In fact, it's quite a bit more
Right.
suspicious if they do.
Well, if it's the Commonwealth's claim that he just suddenly blurted out, my mother didn't know the car was stolen, then particularly given the illegal entry on both of those issues, Gaudette's entitled to an evidentiary hearing where we can actually get testimony from police. And it's actually notable with the illegal entry that the Commonwealth never takes a clear position, either in response to the new trial motion or in its brief on appeal, whether the police ever entered at all, whether they had a permissible basis for doing so. It never actually takes a position. And I'd argue that there is an inference you can take from that it is a viable claim. They could have resolved this. They could have submitted an affidavit from police saying we never went inside the room, and then the trial judge would have had his discretion to credit the police affidavit and discredit Michelle's affidavit, and would have had everything he needed to deny it without an evidentiary hearing. In this case, he didn't. So I'd like to discuss humane practice instruction a little bit, if I may, as well. In light of the state testimony that both the guys that the police had threatened to arrest Michelle too in his presence, you say there couldn't possibly be an issue about exactly how long there was between them, but it was the next thing that he said. The jury should have received this instruction even without a request from defense counsel. And Gaudette's position is that it caused a substantial risk of a miscarriage of justice, because there was a strong possibility that the jury convicted him after crediting the police testimony as to what Craig said, that he blurted out, my mother didn't know the car was stolen, and his mother's testimony that he said that in response to tell us who you are, we'll take your mother in too. And if he did that, and then they would not have done so if properly instructed, that causes the absence of the instruction caused a substantial risk of a miscarriage of justice.
And he was required to do that sua sponte?
Yes, it is measured on substantial. Yes, the judge is required to, even in the absence of a request from defense counsel.
And what is your best case for that proposition?
Well, I have two cases that I would put together for that. There's Commonwealth v. Monroe, and that's 472 Mass 461 in 2015. And it just says threatening defendant with having his child taken away from his girlfriend and raised by strangers, rendered his confession, which was made moments later, that could be minutes, that could be seconds, that rendered that involuntary. And then Commonwealth v. Miller is 68 Mass App Court 835 from 2007. And that case held that failure to hold a hearing on voluntariness and instruct on humane practice would have been error under any standard of review where the defendant testified to a coercive interrogation by Home Depot employees. Let's see what else.
Assuming the humane practice instruction had been given, wouldn't it apply only to the statement, okay, I'm Craig?
I'm not quite sure why. The judge must instruct the jury that the Commonwealth has the burden of proving beyond a reasonable doubt that the statement was voluntary. Why would it only reply to, oh, okay, I'm Craig? Is that the immediate response?
Isn't that the statement that was supposedly elicited by the officer's statement?
But he says,
you know,
okay,
we'll find out who you are, and do you want us to take your mom too? That's the alleged coercion, right?
Yes, that's the alleged coercion.
So the response to that was, okay, I'm Craig.
And then he says, my mother didn't know the car was stolen. I mean, I suppose, is there a period? Does that make it a different statement? If it's still in response to the threat, if he's talking about his mother in response to a threat to his mother, even if there's a pause, you can still characterize that as a response. Saying something is voluntary because you're able to wait a moment before saying it in response to a threat would narrow that exception very seriously. Let me see, what else do I have? So I would like to talk a little bit about the standard of review, failure to file a motion to suppress substantially risked a miscarriage of justice because suppression of the statements would have entitled him to a required finding of not guilty. Commonwealth v. Renaud, I'm going to cite this one too, 81 Mass App Court 26 from 2012. They reversed the trial court's denial of the motion for required finding of not guilty, where the evidence that the defendant had committed a burglary was his EBT card left at the scene. Like Craig's prescription in the glove box, the panel found that just because the card was there was not enough for the jury to find beyond a reasonable doubt that it was left there by the defendant during the burglary. Same with Commonwealth v. Anitas. It was the defendant's DNA on a t-shirt and a bandana that the Commonwealth said they had where the items the robber was seen on video throwing away after the robbery. And they said just because you see the robber on video throwing it away and it has the defendant's DNA on it doesn't mean that alone can prove that he did it. The prescription bottle is even less of a tie to a defendant than an EBT card, DNA or fingerprints. It's not part of your body or something you expect to keep on you at all times. Of course, Michelle testified that she picked the prescription up for him. The other circumstantial evidence the Commonwealth points to is much less incriminating than the additional circumstantial evidence in Commonwealth v. Morris. In that case, phone records showing the defendant knew the other robbers was still not enough that he left the mask with his fingerprints on it at the scene. In Renaud, the defendant also lived in the area and was known to police. The panel said it added nothing to the Commonwealth's case because it didn't show that he committed this specific crime. Craig is showing consciousness of guilt by hiding from police in the bathroom, doesn't say anything about the car in light of the open warrant. His presence in the motel room matching the car's parking space can be compared to Commonwealth v. Prentice P. And that's 57 Mass App Court 766 from 2003, where this court found insufficient evidence to support a guilty verdict where a juvenile was found kneeling beside a stolen vehicle that was up on a jack with a tire iron and crowbar nearby, and he ran when police approached him. Just like that case, we have him in the vicinity of a stolen car, and we have something that might be connected to him found inside it. Case law is clear that without the confession, that would not have been enough to pass a motion for a required finding. And so if trial counsel passed up a motion to suppress with a valid basis, he lost his client a meaningful chance and he is entitled to a new trial. Thank you very much. I'll see you
Carol,
directly.
anything else? Thank you very much. Attorney McLaughlin. We'll put up the time as soon as you're ready.
Great, thank you. I'm ready. Good morning, Your Honors. ADA Laura McLaughlin for the Commonwealth. The defendant's conviction should be affirmed because trial counsel was effective and the defendant was not entitled to a humane practice instruction. The defendant has the burden to prove ineffective assistance of counsel. He has not met that burden as there was no viable basis for a motion to suppress. The statement that the defendant made was spontaneous. It was made without any custodial interrogation. Looking at the transcript on page 68, the officer testifies that the defendant was placed into custody. He immediately made a statement that his mother knew nothing about the car. It's the Commonwealth's position that the defendant never made the statement that he claims to make now, is that my mother did not know the car was stolen. Counsel quotes that in their brief. They quoted it throughout their argument that the defendant made a statement, my mother does not know the car was stolen. There's no support to that in the record. What the officer testified to is that the defendant stated, my mother knows nothing about, that he didn't remember the specific words, but it was his memory that the defendant never used the term stolen. The defendant's mother also testified that the defendant never used the word stolen. A second officer testified to not a direct quote of the defendant, but what I would assume to be his interpretation of what the evidence was and what the defendant meant. However, what he did state is that my mother knows nothing about this.
Where were the police when this spontaneous statement was made? Were they in the hotel room or not?
The record is silent on that. It would be the Commonwealth's reasonable interpretation of the facts that the officers were outside the motel room. If they were inside the motel room, it would also be appropriate because they would be acting on the probation warrant and effectuating that arrest, and in the motel room for the limited purpose to effectuate the arrest.
The statement was after they had gone back down to check in the cruiser the photographs of Craig and his brother and ascertained that this was Craig.
Yes, Your Honor.
Correct. Okay. So the statement by the mother, or the statement by the defendant in response to the alleged statement by the officers that, you know, tell us who you are, or we'll take your mother too. That was before they went and checked the photos in the car, correct?
I would have to refresh my memory on the transcript. I'm not sure if that was contained in the transcript through the mother's testimony that police threatened her, or if that's just contained in her affidavit. There was no testimony of the officers to making any of those statements or any inferences that she would be arrested.
But there was testimony at trial about when he said, "Okay, I'm Craig."
Yes, that occurred after police ascertained his true identity. They went to the door. The mother opened the door. She exited her motel room. She looked over a ledge, claimed what type of car are you speaking of? Went back into the motel room. At that point, she said, "My son Craig is in the bathroom." Officers heard the defendant say, "Mom, it's Alex." Unsure who the individual was in the bathroom, police officers went downstairs to their cruiser, ran a check, confirmed that the defendant was in fact Craig, and that there was an active probation warrant for his arrest. Officers then returned to the motel room to effectuate that arrest.
Well, if the police officers came into the hotel room before they find out that Craig's in the bathroom, isn't that suppressing? That's a big if, obviously, but.
He does have a reasonable expectation of privacy in the motel room. However, the facts are silent to when or if the police did in fact enter the motel room. That information is only contained in the affidavit of the defendant's mother. She did not testify to that at trial, that police entered the motel room. That is only contained in her affidavit for a motion for new trial. The judge was able to credit or discredit that, and who is also the trial judge. So great substantial deference should be given to his assessment and evaluation of the affidavits as well as the trial testimony.
So you're saying that he could just discredit mom's affidavit, doesn't have to hold an evidentiary hearing?
That's correct, Your Honor, because the information contained was not a substantial, did not rise to a substantial level to discredit what occurred at the trial.
Why do we think he did that? He discredited the affidavit.
He was the one who was able to assess, the jury is the one who assesses the credibility of the witnesses. Both the mother testified as well as the officers. The jury is the role of the fact finder who has the ability to assess the credibility of the witnesses. They were able to credit or discredit what the mother had testified to. What is alleged in the affidavit did not rise to the level of a substantial issue based on the motion or affidavit. It was the motion judge, who was also the trial judge, decision not to hold an evidentiary hearing. He did, however, allow counsel to argue the motion for new trial without an evidentiary hearing. So he did hear oral argument on the motion for new trial and did deny it.
The one thing I don't get is your sister's got mom, defendant, officer, Sicard, maybe even the defense attorney outside. Why not hear from them? We would have been, the judge would hear from mom, believe her, not believe her, hear from Sicard, believe him if he says he doesn't go in. And this would all have been taken care of like that. Why not allow that hearing to happen when it's all set up for you?
Your Honor, I can't step into the role of what the judge was thinking. However, it's in his discretion to deny the defendant that opportunity to be heard, as if it is his decision, which it clearly was, as he denied the motion, that there was no substantial issue raised by the affidavit or motions.
You say that the decision was a reasonable tactical one, and his defense, as I understand it, was that the evidence was insufficient. If the statements didn't come in, that any evidence that you had would be handicapped by the loss of the statements. So isn't that part of his defense? Why is that a reasonable strategy?
Even if the statements were not admissible, there was sufficient circumstantial evidence of connecting the defendant to a stolen motor vehicle, and the defendant could be convicted on circumstantial evidence alone. Officers had found in the vehicle indication that the vehicle operated without a key with a brake to the ignition switch. They found the prescription for the defendant in the glove compartment. They also found chocolate milk, which was something that the defendant's mother corroborated that he liked. There's also evidence that the vehicle was stolen in close proximity in Fall River.
And then on prong 2, he wouldn't be successful.
Correct, Your Honor. That the vehicle was stolen about an hour away from where it was found, close proximity to the defendant's home. There's also trial counsel's decision could have been to prevent the mother from being impeached at trial. She was the only defense witness. If she testified in a motion to suppress, the Commonwealth would be able to impeach her with prior testimony. And if I just touch upon the humane practice instructions, the Commonwealth's position that there was not substantial evidence of involuntariness. If Your Honors were to credit the affidavit of the mother or her testimony that police threatened her, that would be appropriate within the bounds of an appropriate police interrogation. The cases that were cited by defense counsel involved a great deal of undue burden and undue pressure that it's not present in the case before us. And unless Your Honors have any other questions, I would rest on my brief.
Seeing none, the case will be deemed submitted. Counsel, thank you both for your excellent arguments.
Thank you.
According to the child enticement statute, the intended perpetrator of the underlying qualifying enumerated offense cannot be the victim, as the message to lure must be accompanied by the sender's intent to do one or more of the enumerated criminal acts.
Why do you think that is?
Well, Distler really gets into interpreting the statute, and there's a section in Distler that I really think kind of speaks for it. If I could read it. It is that reasonable readers of the statute will see that it does not criminalize the mere sending of sexually explicit messages over the internet, even sexually explicit messages to minor. Rather, when subsections A and B are read together, it is readily apparent that the statute only criminalizes such messages that lure, induce, persuade, tempt, incite, solicit, or invite the recipient to take certain actions, enter a house or an automobile, if the messages are accompanied by the sender's intent to do one or more of the enumerated acts. I'm simply applying the interpretation of the statute. And according to the statute, it reads, a verdict on the theory that the victim enticed, that the victim of the enticement was the intended perpetrator of the enumerated offense of child pornography, not the defendant. I don't think it can stand. One of the other things in Distler says that the statute doesn't require any type of agreement or reliance or any other action on the part of the person who receives the enticement. Now, I don't think that's to say that the intended perpetrator of the enumerated offense must be the enticer, must not be the enticer, as it would not be in the case of a joint venture where the enticer lures a victim to a location intending for a co-venturer to commit the enumerated offense. In a scenario like that, the co-venturer that's committing the offense shares the intent with the enticer under some sort of, imputed kind of intention. So, that's kind of how I read the statute.
The statute says he or another person. Why isn't EM another person?
It would be the other person in that co-venture scenario where A entices X out to a location for B, A's co-venturer, to commit the enumerated offense. In that scenario, A is intending to entice X so B can commit the enumerated offense. B, in a joint venture, also shares the sender's intent and will be the perpetrator of the enumerated offense.
I'm concerned that your client asked for nude pictures. Why does it matter that he didn't actually wind up getting any, as long as that was what he was asking for and that was his intent to have the child pornography? Well,
if I could kind of get to that, that's a good question, and that's kind of down the line. I think the evidence is insufficient to prove that either the defendant intended to violate the child pornography statute or the defendant intended for the victim to violate the child pornography statute. The district court, when interpreting the word intent, applied the rule of leniency. saying the benefit of the ambiguity in the statute must be given to the defendant. So I looked at what benefit the ambiguity in the statute brings the defendant. First off, a defendant in a standalone child pornography case would not be able to argue some sort of lack of capacity or mental impairment short of insanity. I think a defendant in a child pornography in the enticement scenario would be able to argue that, because you know, I don't want to trying to step lively, not to walk through this briar patch here involving the differences between general and specific intent. I'll say the benefit increases the burden on the Commonwealth, which is now charged with having to prove the defendant acted with a higher level of culpability. More specifically, he acted with purposeful intent or purposely intended, rather than knowing intent. Now, there's like a real paucity of words attributed to the defendant in this case. You know, even though the police had his cell phone, his laptop, and his tablet, the court is aware that in most of these cases, live and breathe on cell phone text message conversations, usually, or instant messenger or Facebook Messenger, messages. We don't have any of that. So the defendant neither explicitly or implicitly evinced an intention to possess images depicting individuals either under 18 or individuals under 18 in a lewd pose. So what I did was I basically viewed the evidence in the context of the lower knew or should have known burden. It's a lower level of culpability. Even according to that lower level, I think the evidence is insufficient to prove the defendant had actual constructive knowledge, and there's insufficient evidence to prove that he intended that his advances be directed at the underage person. The evidence is insufficient to prove that he had a specific intent, really, because it's insufficient to even prove he had a general intent. Now, there's no evidence that EM, the victim in this, ever told the defendant her age. There's no evidence of the defendant acknowledging her age. EM testified on cross that she did.
Counsel, if I could interrupt you, with respect to the male, SK, your client knew how old he was. He knew that SK was close friends, best friends, whatever word you want to use with EM, that they were in school together. He was requesting pictures of EM and her classmates. Why isn't that totality of the circumstances, as I've just laid them out, sufficient on the question of age? And the fact that he was buying things for them, or at least for her, that someone that had attained the age of majority wouldn't need someone to purchase, for example, vape liquid, things like that. If you take that in the totality, in the light most favorable to the Commonwealth, as we must do, what's missing?
Well, I think, the accusation from SK came out of nowhere. It's the first time it was alleged. The defendant was charged with 5 offenses relevant to SK, 6 if you include the lesser included of statutory rape. 2 of those offenses were life felonies. SK's testimony about the defendant giving him some nude photos of high school girls in exchange for money came on the redirect. At the time, SK said that it happened later in the relationship in May or June, I believe. At that time, he was 17. I believe, seniors in high school straddle ages 17 and 18. He said it's nudes of high school girls. He doesn't explicitly say what class or anything like that. So,
but is that looking through the lens in the light most favorable to the Commonwealth or to your client?
I mean, I think it's an inference. I think it's an assumption you'd have to make. I don't think it's an inference that you draw that, oh, high school girls would have to be somebody under the age of 18. Now, the other thing was SK was the last fact witness in this whole trial, and his testimony came out on redirect. And after the redirect, the evidence was insufficient to support a charge of dissemination of harmful matter to SK, and that charge was directed out. So was the evidence insufficient to prove that there was an exchange of money or agreeing to anything having to do with sex for a fee? So tactically, it didn't make any sense for defense counsel to address any of the issues regarding exchanges of money or exchanges of nude photographs during the recross examination, because really doing so would have kind of given life to the charges of sex for a fee and dissemination of harmful matter, because that's what his allegation kind of dealt with: exchanging photos, disseminating, and exchanges of money. So really,
I'm confused because this isn't an ineffective assistance claim. This is a sufficiency claim.
yeah, I know. I'm just saying it's, to hang their hat on testimony from an accuser who, all 5 or 6 of his charges, the defendant was found not guilty of. And it's the first time it was just put on us. I just, to hang your hat on it, I don't really see that. So.
Can I ask you, this is around page 25 or so of your brief, with respect to the intention to possess child pornography. Is it your argument that EM cannot be the person that he intended to possess child pornography under the enticement statute?
I would say that's my reading of it. I would also say that there's.
And do you have a case that says that?
Not explicitly. I think interpreting it is, well, yeah, I think it's Dissler. I think Dissler states that the messages need to be accompanied by the sender's intent to do one of the enumerated criminal acts. It doesn't say anything about the victim. It goes on to say that any type of agreement, the statute doesn't require an agreement or reliance or action on the part of the person who receives the enticement. That's why enticing to a undercover police officer is something that can be done, and the impossibility argument kind of fails. So as far as age goes, EM testified that she did not speak about her social life. There's no evidence EM talked about what grade she was in or that she played freshman sports. There's no evidence that would provide a base or reference that would allow an objectively reasonable person to infer that EM was under the age of 18. Furthermore, multiple times EM testified that the defendant never specified or asked for photographs of women of specific ages, stating that the defendant didn't ask for any age. He never said anything about age. Now, in child pornography cases, you can rely on the physical appearance to determine the age in marked extremes. In the Hall case, the jury viewed a 4-second video footage of the victim's SANE interview that was taped 3 years before the trial. That allowed the jury to get a good look at what the victim looked like at the time the crime was committed. In the instant case, EM testified before the jury when she was about 19, which is 4 years after the alleged conduct occurred, and the jury wasn't provided any image of what she looked like at the time of the incident in question. Also, in the light most favorable of the Commonwealth, EM was 15 at the time. I don't think that is enough of a gap between the age of 15 and 18. I don't think that's a marked extreme enough, a sufficient extreme to sustain kind of the burdens, the Commonwealth's burden. Now, the Commonwealth also argued that the defendant should have reasonably known that his requests were subjected to children under the age of 18 based on a belief that the victim's friend was under the age of 16. We went over that, yeah. They also argued that the defendant's awareness of the victim's need for a driver to bring her places. She never told the defendant, oh, I don't have a license or anything. And I'd say that, Uber and Lyft have a combined market cap of about 75 billion. And that's like after Corona, based on the whole premise of people needing rides to go places. So age is a factor, but, I don't think you can infer that, it is the factor. As far as lewd images, the bill in particular alleges that the defendant would ask EM while she was 14 and 50 to show him photos of her and her friends, and to show boob, ass photos, and sometimes vagina photos. The only evidence of going to lewd exposition is EM's testimony on direct that the defendant wanted to see photos of these various body parts. And as we know, nudity alone is not enough to render a photograph lewd. It's the lewd exposition of the genitals and pubic areas, buttocks of the female that's required. Now, in
What about
utilizing
the photos that were found on his computer? I think there were two. Are those corroborative evidence?
well, the defendant was not charged with child pornography. The images clearly are not child pornography. So he was possessing legal pornography. I don't see how that goes to an element in that regard. I'd expect the court to take notice of that it is not child pornography and to give it the weight that really those photos deserve. The DOS factors also kind of go through 6 kind of points on what to look at when assessing what is child pornography.
Sounds like just your time is about to expire. So if there's something you want to tell us in conclusion.
Well, he also did not actually possess it. And the enticement element is also very lacking in that he never called her out anywhere. He never extended an open invitation. He simply asked while he was with her on 2 occasions or 1 occasion, can I see some photographs? I don't think that's enough to entice somebody to a location.
Thank you. I think we'll have to leave it there.
Thank you.
Attorney Black. Uh-oh, we've got to unmute you. Hold on. All right.
It might have been me. I had myself muted during my brother's argument. I apologize for that, but good morning.
No worries.
It's actually good that I was muted because I said good afternoon at first, so probably better. But 88 Johanna Black on behalf of the Commonwealth. And may it please the court, I am going to start with my brother's argument about the perpetrator of the crime that's intended not being able to be the inciter. The Commonwealth disagrees with that. The quote that my brother relies on from Disler was actually in the context of the facts of that case, which is different from our case, because in Disler, it was the defendant who wanted to commit one of the enumerated offenses. Here, in our case, as you know, the defendant wanted the victim to possess the child pornography, so to commit.
Your brother's reading to me suggests that you'd always have to have sort of co-defendants or co-venturers, right?
When you say always,
well,
so,
he seems to suggest that one person can't be both, if you will. You don't necessarily disagree with that. You're just saying that the victim can be the person to possess the pornography.
I'm saying the victim can be the person to possess the pornography. I also believe that the person who's committing or intended to commit the enumerated offense could also be the inciter or the defendant in another case, or the defendant of the charge of enticement of a child under the age of 16. I just think in this case, it's different from the published cases that are out there on this statute, where none of those cases.
Do you have a published case that stands for the proposition that you just recited to us?
No, I don't. But I do know that the Frederico, Massachusetts Appeals Court case from 2007, it's cited in my brief, I believe. It's definitely cited in the defendant's brief. That case touched upon it, but specifically said or explicitly stated, we're not going to go that far. We're not going to answer that question. It's not relevant to the circumstances of this case. And they suggest, the court there suggests that there could be other circumstances where the victim would be the intended perpetrator of an enumerated offense. I think when you look at the purpose of the statute, which is to protect children, it's also stated in, I believe it's Hall, that says it goes on beyond certain other statutes that protect children, goes beyond and actually protects them in areas where they're being lured to because of the defendant of an enticement charge. And I think that would encompass, that protection would encompass a scenario where a defendant's luring the victim to an area and then trying to get that victim to commit a crime, one of the enumerated offenses. So I think when you look at the context that that quote was made in Disler, you look at the fact that there are not any published cases that involve the circumstances like our case. The only published case that touches on the issue doesn't answer it and actually suggests, which is the Commonwealth's position, suggests that our scenario could happen. And you combine that with the purpose of the statute, the Commonwealth's position is that the victim can be the intended perpetrator of an enumerated offense.
Do we have to go there? Do you think there's insufficient evidence that he intended to possess child pornography himself?
I make that as a brief alternative argument at the end of my brief. I don't think it's as strong. I don't think the evidence is as strong as for that position as it is that he definitely wanted the victim to possess the photographs, to possess the child pornography. I think the evidence wasn't explicitly clear in what he meant by requesting the photographs. He didn't, I couldn't find a part in the testimony where he was quoted as saying, send them to me or hand them to me or
He was asking questions in the context of her sex life and what she did with boys, and I don't know. I'm struggling with why would he want her to possess it except to give it to him?
Right. I think there is. So I made the argument because I think there's a reasonable inference that by asking her for those photographs, he wanted them. And by wanting them, you want to control them. You want to have dominion of them. And the fact that she's underage, she's a minor, and he is much older than her, I think there exists the authority and the power inherent in such a difference in age that he could constructively possess even photographs that are on her phone, depending on how, for lack of a better phrase, much under his spell she was. So I think I'm not stepping off of the argument. I just think in light of the evidence, I think it's even stronger that he, at a minimum, wanted her to possess the child pornography.
Well, Kathy, you'd like us to decide that she can be the possessor because that's how it was instructed.
Would I like you to decide that?
Because that's how it was instructed. It was instructed that way, right? That either she or the defendant could be the possessor?
Right.
I have to double check. I'm sorry. I believe you're right, though. I can't believe I'm not sure that I remember explicitly, but that makes sense to me, and I assume that's the case. And would I like you to decide that? I think yes, because I don't think that defendants should be able to lure victims to specific areas that are within the defendant's control, that the victims are underage minors that lack power against who we assume would be the defendant, someone much older, or at least of an adult age, and be able to get them to do things that violate the law, especially where they could be things such as possessing child pornography, which is not protecting children. And it kind of goes against the statute's purpose and kind of throws it in the statute's face, which is meant to protect children. Children shouldn't be able to be manipulated into possessing, disseminating child pornography.
So I don't mean to sound fresh with this question, but why not just ask EM when she's on the stand how old she was?
I think it was asked. So the defendant's not challenging her age. I think the defendant was challenging whether he knew or reasonably should have known how old she was or her friends were. I think she did say that she was 14 or 15 when
it started.
When she met him, I believe.
Right, because at the time of trial, she was older.
Right. And I know at one point on cross, she mentioned something that, something about it happened a year before, which if you do the math, she could have been 15, in the light most favorable defendant, she could have been 16 for part of that time. But again, that was on cross, which your honors don't take into consideration in a sufficiency of the evidence analysis. I also believe the judge instructed the jury that prior inconsistent statements shouldn't be taken for their truth, that they're just used by the jury to evaluate the credibility of the witness. And the jury found in the Commonwealth's favor on the count involving her, which suggests they found her credible. The other fact is that whether she was 16, 17, 15, 14, it doesn't matter. as your honors are aware, I guess it doesn't matter in this appeal because the defendant's not challenging what her age actually was. He's challenging what the defendant believed, right? And for child pornography, the child in the images just needs to be under 18. So she was, and presumably her friends were if they were from school. I think, as I believe it was your honor who pointed out about the vaping liquid, that the friend, I'm going to refer to the victim's friend, the other victim of the charges that the defendant was acquitted of, which that evidence, as your honors are aware, can still be used in the sufficiency analysis. It's not like he was a separate trial prior to this trial and was acquitted of those charges. They occurred at the same time as evidence that the jury was entitled to use in rendering their verdict on the charge involving the victim. So anyway, I do think, like your honor said, that the fact that the friend asked the defendant to purchase vape liquid for him. So I don't even think we have to go as far to argue that the defendant is aware of the vaping law, but I think the fact that there's evidence that he provided the vape liquid to the friend suggests that he went and got it. So he had to fulfill the requirements to get it. So there's a reasonable inference that he has an idea of how old the friend is, that he's under 18. The fact that the friend is walking from driveway to driveway, and that's how he comes about and meets the defendant, so he's presumably always walking to the defendant's driveway, suggests that he doesn't have a license. At worst, in the light most favorable to the defendant, it may suggest only that he doesn't have a car. But again, the evidence showed that not just did they use the defendant's car, the defendant actually drove the victim and the friend to different places. So I think that evidence suggests that he knew they were under 18. And
what about the evidence of lewd exhibition?
So I think that you can rely on the photographs.
As corroboration.
As corroboration, because they were on his computer at or about.
They were adult women, correct?
I can't say that for sure.
Okay.
I can say the Commonwealth didn't have enough evidence that they were under the age of 18 to charge him. I don't think we really know. But we're not arguing that they're under 18. Okay. And we don't need to for lewdness. We just need to show meet at least some of the DOST factors, which I think I outlined pretty well in my brief. So I think I'm comfortable just relying on my brief arguing why those images are lewd. And I think that the fact that he had those on his computer, in combination with the fact that he's asking the friend for pornographic sites involving bestiality, that he's asking both the friend and the victim about their sexual lives. He has conversations with the friend about the friend's school. Mm-hmm. So presumably he knows the friend is in high school at best and middle school at worst for the defendant in the light most favorable to Commonwealth. He asks what the friend does with girls in terms of his sexual experiences. He asks for stories of both the friend and the victim's sexual experiences. He touches the victim in, I would suggest, lewd ways. You know, he's touching her thigh, asking her if she'd be good to him, treat him good, I believe was his wording. He tries to kiss her. He puts his hand on her lower back when he does things such as hugging her. He does things that make her uncomfortable, which I think also goes to lewdness in terms of when he's asking her for photographs of her and her friends, and he's asking specifically of breasts, of photographs of their nude breasts, their vaginas, and their buttocks. I think when you take those requests in the context of how he treats the victim as well as the victim's friend, and then around the same time he has these images on his computer, I think that that is enough of circumstantial evidence that shows his intent was to obtain lewd photographs. Checking some other things. And again, I would say that, as your honors are aware, sufficiency of that evidence, you can rely on reasonable inferences. And I think that the evidence is sufficient and does provide reasonable inferences to sustain the conviction. I'm going to go through my notes, if your honors don't mind, just to see if there's anything else that I feel that I should highlight before resting on my brief.
Sure.
I will say, just with respect to the enticing element, I argued it in my brief, but I would add that what I argued in my brief is the minimum I would think that we have for evidence that is still sufficient. So I argued in my brief that the fact the defendant was asked to give the victim rides, and that he did start providing the victim with rides, and then she continued to come back and ask for more rides. That shows he sees the opportunity. Yes, she was, based on the evidence, initiating the request for the ride from him. However, he sees that opportunity and provided her the rides, knowing that she's going to come back. She's coming back repeatedly for more. But I think in addition to that, your honors can also take into account the fact that he had been giving the victim's friend, her best friend, things prior to this. He's paying the victim's friend more than he's getting paid from anybody else to do shoveling of the driveway. It's a small driveway and he's getting almost double what he gets from other people to shovel driveways. He's nice to the victim's friend. You know, he offers things to him such as water, which is great. And maybe not on its own very strong evidence, but I think when you look at all of the things that the defendant's doing for these kids, I think that is added evidence, more evidence of what he's doing to kind of entice them to get what he wants later down the road. The Griswold case, I believe it's Griswold. It's one of the cases where, sorry, my time's expired. One of the cases shows that, you know, there doesn't have to be precision of time and place, that a request can be made in the area where a defendant's grooming the victim. And I think here, when you look at what the defendant had been doing for the victim's friend tells the victim, hey, he'll give us rides because he does all this other stuff for me. I know he will. And he starts doing that for the victim. I think that can be considered by your honors, in addition to the fact that he sees the opportunity with the victim to give her rides and then ask for photographs.
I think we'll need to leave it there. Counsel, thank you both for your arguments and your briefs.
We are live.
Thank you. Our next case is, and I apologize if I mispronounce your client's name, BOURSIQUOT versus Universe Healthcare and another, docket 19P 1697. Mr. Blake, you may proceed.
Thank you and good morning, Your Honors.
Here we go.
Thank you and good morning, Your Honors. Daniel Blake representing Fuller Hospital and its CEO, Rachel Legend. The issue before the court is whether plaintiff must arbitrate her employment law claims based on an arbitration agreement that she signed with Fuller Hospital. The key consideration in this analysis is that the agreement contains a delegation provision which reserves to an arbitrator the determination of applicability of the agreement to plaintiff's claims. Plaintiff did not specifically challenge the delegation provision in a way that would have allowed the motion court to consider it. Even if there had been a challenge, the motion court did not analyze the delegation provision specifically. Instead, the motion court ruled on the applicability of the entire agreement to plaintiff's claims. This was clear error.
You disagree
Just briefly on
with the proposition that the delegation of arbitrability has to be clear and unmistakable?
the delegation of arbitrability is contained in the delegation provision. The clear and unmistakable standard goes to whether there was a formation of a contract, Your Honor. If I could just touch briefly on the facts, I know you're familiar with the record. Plaintiff was first engaged by Fuller as an intern in September 2016 as part of her work for a master's degree. At the conclusion of her internship in May 2017, plaintiff continued with Fuller first as a clinical case manager and ultimately as a licensed social worker. She was terminated in August of 2018 and subsequently brought pregnancy and gender discrimination claims under Chapter 151B. During plaintiff's orientation as an intern, she signed an alternative resolution for conflicts agreement, which is the agreement at issue here. By its plain terms, plaintiffs agreed to arbitrate all disputes except for certain defined exceptions like workers' comp claims and unemployment claims. Covered disputes was defined in the agreement to include all disputes which could be resolved in court, including without limitation disputes arising out of or related to the interpretation or application of the agreement. This is the delegation provision, which is at the second paragraph of section 1 and is also bolded on pages 9 and 10 of our brief.
So one of the questions that sticks out to me is, I understand what you say the contract said, and I think if she had never been an intern and she started as an employee and had signed that packet of materials, perhaps our conversation would be different. Perhaps we wouldn't be here. But what cases do you have, or what guidance can you give us on the fact that the plaintiff started out as, I'm assuming, an unpaid intern, or at least an intern, and wasn't an employee, and then there was a change in circumstances, that is, she became an employee? Why was she not required to sign new materials as an employee?
Well, in terms of the law, Your Honor, the law cited throughout our briefing describes the process. The contract is looked at the time of formation, and the motion court was limited to the idea of whether a contract had been formed. The motion court and all parties cited the National Federation of the Blind case versus the Container Store that talks about that distinction. So in the judge's finding, she found that the contract may not have been applicable to plaintiff because of that exact circumstance that you're asking about, Your Honor, the fact that plaintiff went from an intern to an employee. Well, that's a validity type issue, and where, like here, there's a delegation clause, the court should have sent that applicability issue to the arbitrator.
So that the question of whether or not this document even applied to her had to first be determined by an arbitrator.
Yes, as long as there was a valid agreement, and by valid, the factors are that the contract were formed, the parties manifested their intent to be bound, and plaintiff signed this, that the material terms were present and all the material terms are present in the agreement, and finally that there was consideration.
Let me ask you a hypothetical. What if the plaintiff she was never an intern, she was hired, she signed this packet of materials, she left for 2 years, and then she was hired back, and then these subsequent events took place? Would you say that the agreement she signed in her first period of employment would apply to her second period of employment?
I would say this, Your Honor, that the agreement in section 1 specifically provides that it applies to any future disputes, including disputes arising after employment. I suppose in that case, if she had been terminated and then re-employed, I think it would be a difficult argument to say that the agreement still applied at that point. But that's not
what happened here. First she's employed as an intern, and then she gets a totally different employment as an employee.
She was engaged as an intern and then without any break in service continued on as an employee. And plaintiff argues that by its terms it applies to employment. Well, in fact, plaintiff became an employee, so we would say it absolutely would apply.
So could I return to Justice Ditkoff's original question? We're not supposed to assume that the parties agreed to arbitrate the threshold question of arbitrability unless there's clear and unmistakable evidence that that was the intent. So this delegation provision doesn't say anything about enforceability, unlike the provision at issue in Rent-a-Center. Now you say that enforceability is encompassed within the word application. How does that qualify as clear and unmistakable evidence? And then do you have a case that supports that proposition?
So in terms of case law that supports the proposition, I think if you look at the cases cited by the motion court, and particularly the Brewster wall covering case, talks about manifestation by is judged on an objective basis. And therefore, plaintiff by signing the agreement has manifestly indicated her assent. Subjective issues, and I'm thinking about footnote 35 of that case, subjective issues like those raised by plaintiff are not considered at the outset. And there's no challenge here.
I understand, but the delegation provision here doesn't cover the enforceability of the contract. So there has to be clear and unmistakable evidence of what parties agree to send to the arbitrator. So I'm asking, is there a case that says a delegation provision of this type that doesn't expressly say enforceability, questions of enforceability, or the arbitrator nonetheless encompass those kinds of questions?
So I'm thinking about the Supreme Court's decision in the Shin case, and that's cited in our papers. And in that case as well, the specific term enforceability was not used, but the parties talked about.
That's right, and I read that case, but the court expressly declined to answer the question whether the delegation provision in that case, as a matter of fact, delegated arbitrability and remanded to the Court of Appeals to determine that issue. So I don't think that really supports your position. So is there any other case you can point us to? Because it seems to me that the question of whether the agreement applies to interns is a question of application that's clearly encompassed in the delegation provision. But some of the other arguments, such as fraud in the inducement and whether the plaintiff meaningfully assented, that seems to me to be a little bit different. It's a question of enforceability as opposed to application.
So I think the best discussion with regard to this distinction is in the National Federation case that talks about the difference between contract formation and issues of applicability, or what the First Circuit terms there to be validity of the agreement. And in this case, there's no challenge, really, a sufficient challenge to the formation of the agreement. Plaintiff argues that it should not apply, and the court found that it should not apply based on a change of circumstance. But that was the exact type of question that was reserved for an arbitrator by virtue of the delegation provision.
All right, I don't think I'm being clear about my question, but let's say that the delegation provision said only, it didn't say application, it just said interpretation. Questions concerning interpretations of this agreement go to the arbitrator. Would your argument still be the same, that issues such as fraud and the inducement, et cetera, that would still be encompassed within the scope of the delegation provision?
So there's a distinction in the fraud arena. There's a distinction as to whether or not there's a delegation provision. If there is a delegation provision, then issues of fraud and the inducement would actually be reserved for the arbitrator and not for the court.
But it depends on what the provision says, right? I mean, that's what I'm asking.
I understand, Your Honor. So I don't think the fact that the term enforceability is not included specifically, I don't believe changes the analysis. When the language says all disputes, including without limitation, those related to applicability. And the motion court's decision here is exactly on the point of applicability and not the point of contract formation. Shall I proceed?
Yes, please.
Thank you. So I wanted to talk about the issue of the lack of a challenge. So there is a delegation provision contained in this agreement, and it's a matter of Supreme Court law that if there's no challenge to the delegation provision specifically, then the court must send the case to an arbitrator to decide applicability of the agreement. Here, it's undisputed that plaintiff did not challenge the delegation provision in her opposition papers to the motion to compel. She did raise it only at oral argument by making a statement that she in fact challenged the delegation provision. But her discussion thereafter about the delegation provision went to the agreement as a whole and not specifically to the delegation provision. And an example with that would be the arguments concerning the use of the term employee, which that term does not appear in the delegation provision, it appears elsewhere in the contract. So it's discussed in Rent-A-Center, a challenge like this to the arbitration agreement as a whole is insufficient to constitute a specific challenge to the delegation provision. And in the absence of a challenge, the motion court was required to send the case to the arbitrator for determination of arbitrability. And the court did not do so. And in fact, the court didn't even discuss the delegation provision, omitting it entirely from a block quote concerning arbitration.
You still maintain that the motion judge needs to dismiss the case?
No, Your Honor, we would not press on that issue. We think it should be sent to arbitration. Some principles, general principles to keep in mind in consideration of this issue is that first, that arbitration is heavily favored by both statute and case law on both the federal and state level. Second, it's well established that parties can agree to delegate what's termed gateway issues like this to an arbitrator. And third, that the delegation provision, even when it's contained within an agreement, is considered separate and apart from the rest of the agreement. It's severable. The court's finding here is on page 10, and the judge wrote there that there's a fact question about whether the parties mutually intended the agreement to apply to any permanent paid employment that BOURSIQUOT might obtain following her internship. And the judge specifically, again, used the term application there, which was an issue reserved for the arbitrator and not an issue for the court. The court doesn't mention the Rent-A-Center decision at all, except in a footnote on page 10, footnote 2. And Rent-A-Center is quoted there, or I should say is cited there, and there's a parenthetical that describes its holding. But respectfully, that last line of that footnote doesn't relate to anything in the court's discussion above on page 10. And therefore, we would say that the court failed to consider Rent-A-Center and its obligations to consider the delegation specifically if there had been a challenge, and if not, to send this matter directly to arbitration.
Actually, we have about 30 seconds left if there's anything you want to conclude with.
Again, I would point the court to the National Federation case cited by everyone in this instance, and specifically to a quote by the First Circuit in that case on page 81 that says, even within the validity challenge realm, there's another distinction. A challenge to the validity of an entire contract containing an arbitration clause, I should say arbitration provision, must go to an arbitrator. In this case, must go to an arbitrator.
Thank you very much. Attorney Rooks, when you're ready.
Thank you. Ms. BOURSIQUOT was not an employee at the time that she signed the document that's at issue here. She was an intern, she was unpaid, she was a graduate student working on a degree who got an internship to help complete that degree. The agreement drafted by the appellants repeatedly, exclusively, and expressly refers to the employment relationship, the relationship between an employee and Fuller Hospital.
Why isn't that a question of interpretation or application of the agreement?
So I think that's more a question of enforceability because it goes to the formation of the contract. I don't see how she can how she can assent to that contract that calls for an employee when, particularly when you consider the facts here, the facts that she
signed it, right? So why isn't that more or less dispositive about whether the contract was formed? Now, whether it applies to her once she came back as an actual employee, she might have good arguments that it doesn't, but why doesn't that go to the arbitrator?
So I would say that I don't think the signature is the end all and be all of contract formation in this case, particularly when you consider the circumstances surrounding the execution of the agreement. When she received this package of documents, she specifically asked. This isn't a case like a click wrap agreement or a credit card adhesion contract or something like that, where somebody just doesn't read it. This is a case where she looked over the documents, specifically asked whether this docket, whether this should all apply to me, and it was represented by Fuller Hospital that if it's not relevant to you, we'll take it out. So I think that cuts against, any sort of meeting of the minds argument, even despite the signature.
But I didn't find any place where you raised fraud and the inducement below.
Say again?
I didn't see any place where you raised fraud and the inducement below. Did I miss it?
No, it was not raised below. I think it's more, I think the defense that was raised below is more, goes to unconscionability.
So you cite St. Fleur for the proposition that fraud and the inducement goes to the question of formation of the contract. But St. Fleur cites an older case court, which says that a claim of fraud of inducement in the contract is a threshold question for the arbitrator. Do you have a case that says otherwise?
I don't have a cite for that particular proposition.
How do you respond to counsel's argument that you did not raise the enforceability of the delegation provision below?
I would respond first by saying that we did raise it.
You were asked if you were raising it, you said yes, but did you make a specific argument either in writing or orally below?
That I would guess I would preface it by saying I don't think that the analysis actually gets to Rent-A-Center, because I don't think a contract was ever formed, or that there's clear and unmistakable evidence that they agreed to arbitrate arbitrability. But if you do get to the Rent-A-Center question, we made the express challenge. Perhaps the argument didn't quite specifically go to the challenge of the delegation, or the argument itself wasn't separated into the two parts, but I think it certainly went to the challenge of the delegation provision.
So what is the argument that's specific to the delegation provision as opposed to the contract as a whole?
So the argument that's specific to the delegation provision is that it does not contain the term enforceability, and that the Rent-A-Center decision, or the agreement at issue in Rent-A-Center did. It said enforceability, interpretation, formation, and applicability.
Okay, but you don't have any specific argument that the delegation provision specifically is unconscionable as opposed to the agreement as a whole being unconscionable. That's what I'm asking.
That it's,
that's the Rent-A-Center question, right? Is that you're saying that this agreement is not enforceable because it's unconscionable, and Rent-A-Center says that in order for that question not to go to the arbitrator, you have to make a specific unconscionability challenge to the delegation provision. And I'm asking whether you have a specific argument that goes to the delegation provision as opposed to the agreement as a whole.
For an unconscionability argument, not a specific unconscionability argument as goes to that particular provision. So I think that the legal framework here is sort of a three-step analysis, and you have to decide whether a contract was formed in the first place, whether, if so, whether there was is clear and unmistakable evidence in the absence of the word enforceability that the parties agreed to arbitrate arbitrability. And third, I think only if you get through those two prongs do you get to the Rent-A-Center agreement, or the Rent-A-Center argument rather. And I think that that goes to whether did the lower court have the authority to decide whether the claims were arbitrable, or what was that reserved for an arbitrator. And I think in the absence of the word enforceability, I mean, the Morgantown case, which I cited, which is, I agree with brother counsel's proposition that that's not controlling here, but that I think it is persuasive that court dismissed out of hand said this doesn't contain the word enforceability, Rent-A-Center doesn't apply. It was as simple as that. That was the end of the analysis for that court. And I think that that's a persuasive case that should be adopted here. And I think that the appellants don't offer any case that really counters that proposition. That they offer the Henry Schein case, which in fact I think, as you pointed out, Justice Shin, I think it doesn't really support his position. The Schein case specifically was related to the issue of whether the wholly groundless standard, which had been applied by the Fifth Circuit, was appropriate, and the court found that it was not. But and on remand, the Fifth Circuit actually did get rid of that arbitration agreement using the clear and unmistakable standard. And unlike the appellant's argument that the clear and unmistakable standard goes only to the manifestation of assent, that is not how the Fifth Circuit on remand interpreted it. They looked at the substantive issues.
Well, for the judge here said that what she was planning on doing was determine whether the parties mutually intended the agreement to apply to any permanent paid employment that BOURSIQUOT might obtain following her internship. So that's what she was planning on doing next, deciding that. Why isn't that interpretation or application?
I'm sorry, could you?
What the judge said, there's a factual question whether the parties mutually intended the agreement to apply to any permanent paid employment that BOURSIQUOT might obtain following her internship. So presumably the next thing she was going to do was decide that. So why isn't that question a question of interpretation or application?
Again, I think it goes to enforcement. I think in the words, I would point out that the appellants are asking the court to decide this on a technical and procedural grounds, but at the same time asking the court to say that interns, the word intern and the word employee are basically the same thing when they're not, and B, that applicability encompasses the term enforceability, which it does not. And I think that this issue goes to enforceability. The word apply and the word enforce mean different things. And by my reading of it, and I looked at Black's Law Dictionary, apply, it refers specifically to subject matter. I think the definition is to put to use with a particular subject matter. And enforce means to give force or effect to. And I think that this issue here of whether she was, whether this is, I think what the judge was getting at was whether this agreement is enforceable against her in this situation.
All right, well, let's just assume that it's a question of enforceability. The delegation provision, it says that it applies without limitation to claims, including those of interpretation application. Then it very broadly says that except as otherwise provided in the agreement, all disputes are to be resolved by the arbitrator. So why is that not clear and unmistakable evidence that questions of enforceability also go to the arbitrator?
I mean, I think you have to look at the context and look at this as a whole. I think that it's not clear and unmistakable because when Ms. BOURSIQUOT was presented with the agreement, she was not an employee, she was an intern. It did say all, but I don't think it's not a clear and unmistakable where it's not specified. Excuse me,
that's not what clear and unmistakable means in this context. What it means in this context is the manifestation of intent. We don't look at the circumstances surrounding the signing of the agreement. We look at the words of the contract. And here it seems like the delegation provision very broadly applies to all disputes except as provided in the agreements.
It does, and I would respectfully disagree that the clear and unmistakable refers specifically to the manifestation of assent. I think that is a footnote in dicta from Justice Scalia in the Rent-A-Center decision, but that's not been followed. That that was a 5-4 decision, and that the Henry Schein case, that court said nothing about it being a manifestation of the assent, and when it went back on remand, the Fifth Circuit did not decide it that way.
Counsel, do you have anything further?
I do. I think in terms of, I think with the policy, and there's a few policy and circumstantial considerations that we should note. I think that when you take all the circumstances and the facts that are at issue here, and I know you've read the briefs and you read Ms. BOURSIQUOT's affidavit, I think the equities sort of weigh towards her, and it would be, unfair to enforce this against her, given that she was not an employee at the time that she signed this agreement. I would liken the agreement to, say, a consent form in a hospital scenario, where it called for a child, or rather, if a minor had to consent to something, that it called for an adult or a parent's legal guardian's signature, but the child signed it. I don't think that in that case you have an effective actual formed contract, even though the child signed it. And I think it's sort of an applicable analogy here. That the hospital couldn't later use that after the person became an adult and said, well, we have this signature, so this form will work. I think that this being a civil rights matter, a matter of gender and pregnancy discrimination claims, I would suggest or submit that the constitutional right to a jury trial is, particularly important here, and particularly sacred. And I would also say that forcing the appellants, or Ms. BOURSIQUOT's claims against the appellants into arbitration, would force this into two separate proceedings, because there's a third defendant here who is not subject to an arbitration agreement. And so the underlying policy considerations of judicial economy that are related to sort of the promotion of arbitration, I think it cuts against that. Because here you would have two separate proceedings with potentially all parties having to be involved as witnesses.
I seem to be assuming that the arbitrator would definitely find that this agreement applies to her as an employee. Is there some reason you think that?
No, I don't think that. I guess I don't think that the arbitrator would definitely find that. I just think that it was within Judge Kelly's right to make that determination based on the fact that or at least our arguments that the contract was never formed, and that there is not clear and unmistakable evidence that they agreed to arbitrate arbitrability.
Kelly might find that the arbitration agreement applies to her as an employee as well. Is there some reason you seem convinced you have a better shot with Judge Kelly than with an arbitrator?
No, I don't have a specific reason to think that. No.
Just curious.
I think that's all I have.
Unless the panel has any other additional questions, I see none. We will take the matter under advisement, gentlemen. Thank you both for excellent briefs and excellent arguments. Take good care. Thank you.
Thank you, Justice Blake.
All right, we are live.
Thank you. This is our last case for hearing today. It is the Department of Children and Families versus Mother, docket number 19P1703. Attorney Robin, when you are ready.
Thank you. Good afternoon, Your Honors. May it please the court, my name is Valerie Robin, and I represent the appellant, the mother, who has had her parental rights terminated as to her son. For purposes of this Zoom oral argument, I'd like to indicate that the mother is present along with her maternal grandmother. As I understand, they're watching live argument on the YouTube channel. This is about a teenage mother with a low IQ, 1 point above what is considered mental retardation or an intellectual disability, with a reading level of a first to second grader who had her son taken away at birth. While this trial occurred in March 2019, DCF's case as to mother's current unfitness for this child was based on documentary evidence from the 2014 to 2016 period, which much of it referenced time periods dating as far back as to when she was in the elementary school. With stale evidence and no evidence of mother's current fitness for this child, the court placed the burden on mother to rebut what DCF never presented. The court concluded in numerous conclusions of law that mother offered no evidence or no information on specific issues, such as fulfilling a non-existent service plan for present functioning. In essence, DCF cut corners failed to present evidence as to mother's current fitness, and even about her visits with a child, leaving the burden
I'm
on.
going to have you pause for just a second at 1327. Megan, if you could pause us, it looks like we lost Mr. Salcido.
Okay, we are live again, and
Okay, so we've had some technical problems for those of you that are watching. We are going to start the clock over again, and Attorney Robin will continue her argument. To the extent that her clock goes beyond the total of 15 minutes, we will give Attorney Deely and Attorney Salcido additional time should they need it, so that everything is fair and equitable. And we apologize for the interruption. It does happen with technology. So Attorney Robin, when you are ready, we'll put the clock back up.
Thank you, Your Honors. As I'm not certain where my friend fell off into the technology issue, I'll try not to repeat myself, but I'll just back up a little bit for 1 second. Basically, the court concluded in numerous conclusions of law that mother offered no evidence or no information on specific issues, such as fulfilling non-existent service plans or present functioning. In essence, DCF cut corners and failed to present evidence as to mother's current fitness and even about her visits with the child, leaving the burden of mother.
I want to ask you two questions, though, about that before you get on to the visits. I guess that my first question is that it's Judge Lyman certainly used the term no evidence throughout at least the conclusions of law part of his decision. But if you read those in context, and I think we're guided by the Terrence case in this regard, it seems to me that it perhaps not the most artful term, and there are better ways to perhaps say it, but in the totality of the circumstances, I read it to suggest that he was not changing or shifting the burden of proof as you've described it, but really sort of taking a global view of the evidence about what evidence he did have and what evidence he didn't have without shifting the burden. So I'm wondering if you can respond to that. And as part of that question, I know that you said the documentary evidence ended by, I think, July of 2016, but if mother was not in touch with the department and was either parts unknown or in New York or somewhere else, or at least not involving herself with the department, how could the department put on evidence if she was essentially gone?
So I'll try to address both parts of your question, Your Honor. First of all, with regards to the Terrence case, this isn't the Terrence case. In the Terrence case, I think that the word was demonstrated. And if you look in this particular case, Judge Lyman does do that, for example, in conclusion 16. That's not what I'm addressing. And when you look at the totality of the circumstances in terms of putting it in context, you have to look at what the evidence. For example, when the judge says, mother presented no evidence that she complied with the service plans. Well, the record had no evidence of any service plans. It wasn't in evidence. Similarly, where the documentary evidence stopped effectively as of July 2016, where it showed that mother was complying with her services, she was receiving services through the Lynn Community Health Services, psychiatric. She was getting services with Earmark, etc. And then you have nothing. Now you ask the question, Your Honor, well, what happens if the department can't get in contact with the mother? What I would suggest, Your Honor, is the burden means the burden. It's the department's obligation then to put on evidence of that information. You can't, in all areas of the law, whether it's criminal, civil, or whatnot, the prosecutor, for example, must decide how to meet its burden. It's his or her job. Similarly, in a civil case, it's no different in this case. In fact, it's very important because they're seeking to terminate mother's parental rights. They're taking.
Why isn't perhaps a voluntary absence from the state or from the department evidence of her unfitness?
Well, certainly, and there is case law that could suggest that. But when mother wasn't present at this trial, the inference that DCF asked for and the inference that the court found was very specific. It was if mother were to testify she wouldn't be able to offer any evidence to rebut what DCF presented. Strategically or otherwise, it shouldn't be the burden on mother to affirmatively offer evidence of what DCF did not provide.
Well, we terminate father's parental rights all the time when he is either unknown, unnamed, or parts unknown, right? So I think about that situation and I compare it to what we have here, and we have a mom who has a significant backstory, who has absented herself from the process, even to the point where she, despite best efforts, wouldn't come into the courtroom. So DCF can't produce evidence that doesn't exist, right?
Well, yes and no. Certainly DCF can't, if they can't get the testimony from the mother, that doesn't mean that DCF can't present evidence. For example, in a hypothetical sense, if this was the case where DCF multiple times was trying to contact mother refused to come, they could present evidence. They could present evidence with all the letters they sent to me. They could do it. But what they chose to present, this was DCF's case, right? What they chose to present is they put a social worker on it who had very limited experience. She couldn't, it wasn't that I was going to the areas of visitation, Your Honor, but she couldn't even testify as to what that involved. This DCF worker, the last court investigative report was July 2018, not 2016. And interestingly enough, that court investigator doesn't even speak with this DCF. It's another DCF worker. And even then, they don't dispute or they don't offer anything affirmatively that suggests that mother isn't visiting with the child. So yes, mother did not want to come into the courtroom, which is very different of not showing up. And that goes to the backstory of what's going on here. And that's why it was so imperative that actually DCF to meet its burden.
That since February 2018, only one visit, monthly letters were sent out, but mother refuses to provide a residential address or engage in services, wouldn't come to meetings to schedule a home visit, that she sent out updated service plans. Why doesn't that show at least that she's disengaged from February 2018 till March 2019?
Well, on several levels. First of all, that has to be sort of met by a preponderance of the evidence standard. The testimony specifically as to service plans, which is critical in this case, is there wasn't one service plan presented. And even when this social worker was asked on cross-examination, what were the services? It was to stay in contact with mother. I mean, that should send a signal right then and there.
Well,
so
what happens to me is if the service plan is just maintain contact and engage with DCF, and mother won't even do that, then how can DCF provide any more services if she won't even engage them? They can't even figure out what services they can provide or she can need in that circumstance.
So I think the question, Your Honor, though, is if mother, and in fact, she did contact the social worker, because the social worker said she spoke to her a couple of times over the summer. She met with her at the visit. So it wasn't that there was no contact. But if the court is going to take the position that because DCF says the services they're providing is to maintain contact, and they believe that contact wasn't sufficient, that that's enough to terminate. I mean, I take it one step further, and if you look at, for example, Child's brief on page 41, I mean, they don't really have anything. The social worker couldn't testify. That was objected to and sustained as to how many visits. So Child argues that there wasn't a motion to strike after it was objected to and sustained. Or alternatively,
3 pages later, the judge says, she's already testified that mother had no visits for 2 years, and that was not objected to. So that is in evidence. Now, I understand the judge is wrong about that, but when your predecessor doesn't correct the judge on that, especially when the DCF lawyer is saying, I'll bring in the other social worker, why don't we have to take that now as evidence that's come in?
Well, first of all, as you point out, it's 2 years, and yet the judge found that mother hasn't visited since November 2016. The trial was in 2019.
Isn't that supported by exhibits 22 and 23?
Excuse me?
Isn't that finding supported by exhibits 22 and 23?
Well, exhibits 22 and 23, which are the family service and assessment plan, again, that's for mother and a different child. No services were being offered for this particular child. Furthermore, it was hearsay. The judge said at the beginning of the trial in the motion in limine that he was going to, he would weight the evidence accordingly. And
I thought the judge said there were no motions in limine.
There were no
51Bs be limited, but where did your predecessor say anything about these exhibits or any other kind of hearsay?
My predecessor, trial counsel, didn't say anything about the particular hearsay in those records. The judge did say, I believe it's right around page 78, but I might be off in the transcript, did say that he was going to, he wasn't going to spend too much time on what primary fact is, but, he would, in essence, and I'm paraphrasing, that he would, take the evidence accordingly. So
actually, in that part of the transcript, he says he's going to accept the 51As just to set the stage, and then the 51Bs for primary fact, but there's no limitation on any of the other exhibits that came in.
I read it slightly differently, but nonetheless, what I would say, Your Honor, is that we know that it's hearsay when it's in a department's record.
But that's if it's not. Go ahead. I'm sorry. No, go ahead.
If it's not objected to, it's in.
I understand what the court is saying, but I also would refer back to what the judge said during that argument. And I also would just take it one step further. That's all they have. This is based on what's in this record, that's for the mother and another child. I mean, certainly the department should be able to put on its case and should be able to put on its case that, in terms of where, whether mother was present, whether what wasn't present. But this was so critical that in the end of the day, and I do cite it in my brief, in my reply brief, multiple conclusions of law.
Below, did your predecessor counsel file any kind of a motion for reconsideration or clarification, for example, on the issue of the mom signing, or which we know she didn't, but the judge finding that she signed the post-adoption contact agreement? Was there any post-trial motion filed on that?
There was no post-trial motion on that, but I think it raises another issue, that is just one more level of, and again, if you look at the transcript, it appeared that the judge understood that mother wasn't signing this agreement, yet then the court, again, because it had so little evidence, it was forced to rely on either erroneous or objectionable evidence because there was nothing before. And that's how the burden got transferred to mother. So, I mean, essentially, I would ask that, a message needs to be sent that DCF can't cut corners. They need to present its case. If it really means the burden is on DCF, which I believe the case law is very clear as to establish current unfitness, then that's what should happen. It shouldn't be that mother is left then to have to present her case. And I realize I'm watching the clock, but to present her case to then, in essence, have to offer what DCF never offered in the first place. So we'd simply ask to reverse the decision terminating her parental rights, restore mother's right for review and redetermination hearing, and order the juvenile court to direct DCF to provide appropriate services to mother and family, including a reunification therapist to commence immediately. With regards to my other arguments, I would certainly rest on my brief and reply brief and welcome any additional questions.
Seeing none, we will move to Mr. Salcido. Thank you, Ms. Robin.
Thank you.
May it please the court, Richard Salcido for the Department of Children and Families. I think I would like to start by just pointing out that the department's evidence in this case, much of it, as your honors have mentioned, the documentary evidence is from the early part of the case when mother was residing in the local area, was communicating with the department, was cooperating with the department.
What is the evidence that the judge had in below that mom was in New York?
Well, it's mentioned in two of the documents that were admitted into evidence, exhibit number 22 and 23, multiple times mentioned that mother was residing in New York. Mother gave the social worker an address in New York for her to mail the family action plans, and the ongoing social worker testified that mother had moved to New York in November of 2016.
Why did this case take so long to get to trial?
I don't know, Your Honor. I'm not sure about that. I know the department was trying to work with mom early on after November of 2016. I can't really say why it took that much time to move towards trial termination.
Why aren't the service plans in evidence?
I'm sorry, Your Honor?
Why aren't the service plans in evidence? That's very new.
Yeah, I can't answer that one either, Your Honor. I know that the court reports were put into evidence, 51 A's and B's, and the family assessment and family action plan, the most recent one anyway. I think that family action plan essentially, was the same as the one that was the department had relied on before. That basically asked mother to engage in individual therapy, to continue with a parenting support, and to maintain contact with her child and with the department. There are a number of services that are offered early on, and as Justice Blake indicates, those services would have continued or some variation if mother had not moved out of state and disengaged and effectively abandoned the case. The department put in evidence of mother's non-cooperation or lack of engagement in the case, her failure to communicate and engage in services through the ongoing social worker. That ongoing social worker was also the author of or one of the authors of the family assessment and the family action plan.
What concerns me though, Mr. Salcedo, is, unfortunately we see cases that parents don't participate in the trial for any number of reasons. And, this was at best a minimalist case that was put in. And as Attorney Robbins said, we're talking about significant rights. We're talking about the constitutional right to parent. And as Justice Ditkoff points out, there's no service plans. Something went wrong here.
Well, I think that the evidence of what the services that were offered early on are in the record, and the family action plan that was put in is essentially, documents what the services were that were offered to mother. There is, I think it was difficult for the department to document mother's engagement in services, her current level of functioning, all of that while she was absent from the case and was not responding to the department's attempts to reach her, to get her to re-engage, to comply or participate in services.
So to that end, does it even matter whether she was in New York or she was in the next town? The fact that she wasn't engaging which led, I think, Judge Lyman to use the term no evidence. It really didn't matter where mom was, did it? The fact is she wasn't participating.
She wasn't participating, no. I mean, I think if the department had been able to, if she were in contact and in communication with the department while she was living in New York, the department could have coordinated services for her there. It could have taken any number of measures to assist her as they had done before. And but mother failed to respond. And the first time the ongoing social worker heard from her was in November of 2018, she testified to. And at that time, mother admitted to her in that meeting, she had not signed any releases because she had no providers that she was working with. She was even reluctant to give a residential address. She had only provided a mailing address in New York to the department, to the worker. So it's pretty clear that mother was making no effort to work towards reunification with her child. Even during the visit that she was provided after that meeting in November of 2018, she did not use up the entire full hour of the visit with her child, but asked to terminate it early.
What do you make of the judge's use of the expression no evidence in terms of the question of burden shifting?
I think the department had put in evidence that mother was absent from the case, that she was not engaging in services, not visiting with her child, and mother did not rebut that evidence with any evidence of her own. The court was essentially summarizing the evidence that was presented, and there was no evidence of mother's current fitness because she was absent. The department was unable to get her to respond and to assess her current need for services, whatever they may have been. None of that was able to occur because mother was no longer engaged or cooperating with the department.
We did go a bit over with Attorney Robin because of the time break. Is there anything else that you would like to tell us in the next minute or so?
No, I don't think so, Your Honor. I would just rest
make
on
sure
my
the
brief.
panel doesn't have any more questions. Okay, great. Thank you.
Thank you, Your Honor.
Attorney Deely, when you're ready.
Good afternoon, Your Honors. May it please the court, my name is Megan Deely and I represent the appellee child. Even construing the record in mother's favor, the unchallenged record nonetheless shows that mother has had a lifelong struggle with very serious mental health issues and has struggled to engage with or benefit from the services provided to her. Mother had been out of contact with DCF for at least the 13 months prior to trial, except for a single phone call in July and one visit with her son in November 2018, which she ended after 20 minutes. And she had not requested any other visits during that time period. Shortly thereafter, mother had a second child of whom she immediately gave up custody to her mother, which mother conceded in her brief at footnote 5, demonstrated her understanding of her current abilities to properly care for the children. The juvenile court's findings were properly supported and aggregated to clear and convincing evidence of mother's current unfitness, that said unfitness was not temporary, and that termination of parental rights were in my client's best interest. I will note
the
that
child had some significant medical and developmental issues upon birth. Do I read your brief to suggest that the child is now on target developmentally?
The medical issues that he experienced when he was younger were resolved in part through early intervention services. He does have some other struggles that he deals with with regards to behavior. He can be explosive at times, and he requires some additional assistance. Fortunately, his foster parents are both special education teachers and have experience fostering and adopting children with special needs. And I believe it was uncontested that they've done a very good job in meeting those needs. I will just note, with response to your Honor's questions to other counsel, that Exhibit 23 is a service plan
and also that the social worker testified to the contents of one of the service plans. And with regards to why the case took so long to get to trial, I suspect, although I do not know, but I suspect that's in part because mother stipulated to her unfitness in February of 2016. And so because there was an adjudication that the child was in need of care and protection at that time, the federal time standards had been met.
Didn't apply.
Yeah. So in addition to the other factors that I've outlined, as the court noted, mother refused to provide the department with a mailing address. And so the department, as the court had no information about where or what kind of home mother intended to bring her son. Per the Paula case and Serge case, the court can consider whether the parent has a realistic plan to care for her son. And moreover, mother's counsel asserts that, mother's absence of evidence is not evidence of absence. But there was evidence of mother's absence in this case. Specifically, as we've noted, as I noted before, that she was only in contact with the department twice in a 13-month period. And adoption of Mario and adoption of Fran both state that failure of the parent to visit the child for an extended period of time is a relevant consideration with regards to unfitness, especially when considering the extensive evidence of her unfitness earlier in the case. With regards to mother living out of state in New York, none of the evidence is in conflict with one another. Ms. Towers, the social worker's testimony was that mother had moved out of state at least 2 years prior to trial and only visited with her child once during that 13-month period. That did not conflict with the evidence from the court investigator report that mother had been living in New York prior to June 2018. That was evidence from her own mother. And it was consistent with the evidence from exhibits 22 and 23, which again, as your honors noted, were unobjected to. And so they come in for their full probative value.
So counsel, you said that exhibit 23 is a service plan, but I'm looking at it now and it's a family action plan where the subject child is the younger child.
So the terminology has changed from service plan to family action plan, but the document and the contents are the same. With regards to it relating to the current child, there's no bar or evidentiary rule that says that a plan with regards to that relates primarily to one child cannot be relevant.
No, I'm not saying it's not relevant, but the fact remains there are no service plans in this record concerning the subject child.
There was no physical service plan entered, that's correct, but the social worker did testify about what was being asked. And as Justice Ditkoff pointed out, mother could not even comply with the basic requirements of staying in touch once a month with regularly scheduling visits with her child. So she had really apparently given up on having a relationship with her child for at least 13 months, except for this one short visit that she had because she struggled emotionally to complete.
How is the connection going between your client and grandmother and sibling?
Well, I'd have to go outside the record to answer that question. Is that what your honor is asking?
That's what I was asking.
I can say that the child continues to do extremely well in his pre-adoptive home and that he has continued to have contact with his grandmother.
It's only the latter I wanted to know, since that was what the judge ordered.
Yeah, I can say that he's continued to have contact. I don't think I can comment on the extent of that contact.
I just bring it up because sometimes I hear there's a judicial order for post termination visitation, and I find out in oral argument that it's not happening.
Right. Well, in this case, the parties did agree to it, or I should say the child signed off and the pre-adoptive parents signed off on the agreement. And in fact, the pre-adoptive parents had been arranging the visits with the grandmother for quite some time. I think it was approximately 2 years prior to trial. So it wasn't being dictated by the department. They were managing it themselves. And she had attended birthday parties and dance recitals and so forth. And I believe even other children in the home refer to her as Granny. So there appears to have been a substantial relationship maintained there.
Attorney Deely, because we went over with Attorney Robin, is there anything else that you would like to tell us?
I'll just note that with regards to the burden shifting, I don't believe the burden was improperly shifted. Adoption of Terrence, I believe, does rule on this. Ian specifically said that the court specifically quoted the statutory burden of proof and applied it directly to the mother. That's not the case here. And with regards to, whether mother has an obligation to demonstrate her unfitness, once parental deficiencies are identified, the parent does have an obligation to work to correct those deficiencies and to demonstrate their progress. I'd refer you to Chapter 210, Section 3, Part 2, and also Adoption of SARD, which states that the mother has an obligation to seek and utilize appropriate services and to maintain regular contact with the department. With regards to the rest of my argument, I will rest on my brief.
Does the panel
Unless
have any
the justices have any questions?
Seeing none, we will conclude this argument. The case will be deemed submitted. These are always very difficult cases, and counsel, the three of you did a very nice job representing your client.